Clients walk into a family law practice expecting that a signed prenuptial agreement provides an unchallengeable barrier protecting financial assets in a divorce. In the jurisdiction of England and Wales, the reality is different. A prenuptial agreement is not a self-executing or automatically binding legal contract. This creates a friction point in the law: the desire for private financial arrangements versus a broad statutory mandate designed to protect the vulnerable. To navigate this, practitioners have to reconcile the text of a decades-old statute with the evolving rulings of the higher courts. A well-drafted agreement serves as a highly persuasive starting point for a judge, but it is rarely the final word on how assets are divided. The ultimate authority over all financial orders upon divorce is Section 25 of the Matrimonial Causes Act, 1973. This scale represents the discretionary power Section 25 grants courts to distribute assets fairly. The judge weighs statutory factors like current income, earning capacity, and previous living standards. However, the court must give first consideration to the welfare of any minor children. Any private prenuptial agreement must survive the weight of these Section 25 factors to be enforced. Historically, English family courts placed very little weight on prenuptial agreements, frequently overriding them to enforce an equal sharing of assets. The legal baseline changed in 2010 with the Supreme Court decision in Radmacher v. Granatino. The case involved an heiress and her former husband, Nicholas Granatino, who sought a multi-million-pound settlement despite signing an agreement that precluded it. The Supreme Court ruled against Granatino, establishing that the courts should generally give effect to a nuptial agreement that is freely entered into. This created a two-part test. First, both parties must have a full appreciation of the implications of the agreement at the time of signing. Second, the agreement will be upheld provided it is not unfair to hold the parties to their bargain in the current circumstances. The ruling left the 1973 statute intact, but it required judges to treat a validly executed prenup as a significant factor in the final assessment. We visualize this test using three core elements: needs, compensation, and sharing, overseen by the welfare of children. Consider a short marriage with independent legal advice. If the agreement leaves both parties self-sufficient, the fairness gauges remain stable. In precedents like BN v. MA, the court looked at B's exact conditions and respected the terms of the signed contract. In these scenarios, the court restricts the payout to the specific, limited terms outlined in the agreement. Without that agreement, the court would have likely moved toward the yardstick of equality, dividing the assets in half. Because basic needs are met and children are not prejudiced, the court prioritizes the autonomy of the private contract over the principle of equal sharing. The Radmacher test fails the moment an agreement compromises a party's essential requirements. Take a scenario where the marriage produces children and one spouse stops working. An agreement leaving that spouse without housing or failing to provide for the children's needs triggers a system override. In the 2011 case of V versus V, the agreement failed this test. It didn't meet the wife's basic needs after a career break and was grossly unfair to the children. The contract collapsed under scrutiny. The presiding judge afforded the agreement absolutely no weight whatsoever, dividing the assets as if it did not exist. No private contract can successfully waive the statutory duty to provide for basic survival and the welfare of children. In practice, courts rarely enforce an agreement perfectly or discard it entirely. The 2018 ruling in Brack v. Brack shows the more common hybrid reality. In Brack, the parties had signed multiple agreements stating neither would receive maintenance. By the time they divorced, they had 2 children and £11 million in assets. The court found these terms were unfair. However, finding an agreement unfair does not cause it to vanish from the judge's consideration. It remains one of the circumstances the court must balance under Section 25. Instead of equal division, the agreement acts as a ceiling. It limits the award strictly to meeting the vulnerable party's needs, preventing them from claiming a full share of the marital wealth. Even a flawed prenup exerts a gravitational pull, keeping the final award anchored to a strict interpretation of necessity. This creates a practical dilemma for legal advisors. It is difficult to guarantee how an agreement will hold up decades into the future. Legal definitions of needs and fairness are not static. As a marriage progresses and lives change, the threshold for what a court considers fair shifts. This moving target presents a risk to clients seeking a definitive separation of their assets. This unpredictability led to calls for the legal system to move toward a more predictable model. A justice system based on broad judicial discretion is fundamentally at odds with the rigid, fixed nature of a binding contract. The 2014 Law Commission report provided a formal legislative proposal to address this lack of certainty. The central proposal was a new statutory instrument, the Qualifying Nuptial Agreement. This framework would allow couples to definitively exclude certain assets from the court's sharing jurisdiction, providing a level of predictability that does not currently exist. To qualify, an agreement must meet strict procedural requirements, like full financial disclosure and independent legal advice. Yet a vital safeguard remains. A qualifying nuptial agreement can never leave a party without basic needs or compromise children's welfare. While these proposals have been influential, they have not yet been enacted into law by Parliament. Until reformed, prenuptial agreements in England and Wales remain persuasive instruments, but are always subordinate to the court's overriding duty to ensure fairness.